Answers to Part 5 Quizzer Incorporation Law Review. We have 25 items. Number 1. Which of the following is wrong? Yung answer ay letter D. Banks or banking institutions are not allowed to merge or consolidate. Yung mali, yung are not allowed. They are allowed to merge or consolidate. Yung nire-require lang ng law ay mayroong favorable recommendation from the appropriate government agency. Tingnan natin yung ABC. A. Two or more corporations may merge into a single corporation. True. Merger and consolidation must be approved by majority vote of each of the board of the constituent corporations. Majority of the board ng bawat corporation. True. Merger and consolidation must be consented to by at least 2/3 of outstanding capital stock or members. 2/3 of OCS or members. True. Again, number 1, letter D. Number 2, which of the following is not a requisite in the exercise of appraisal right? Yung answer ay letter B. A particular corporate action voted upon by the stockholders was disapproved. Yan yung mali. Dapat approve. Kasi pag dinisapprove, edi wala nang reason to exercise appraisal right. Hindi kasi natuloy yung corporate action to which the stockholder dissented. So, dapat approved. Tingnan natin yung A, C, at D. A. It must be exercised by a dissenting stockholder. So, dapat yung nag-exercise ng appraisal right ay dissenting stockholder. Letter C. There must be a particular corporate action voted upon by the stockholders. So, mayroong particular corporate action na inapprove nga ng stockholders. Letter D. There must be a valid ground for the exercise of such right under the law. Valid ground. Yung grounds lang provided for by law. Like yung investment of corporate funds other than its primary purpose. Valid ground. When there is merger or consolidation. Valid ground. So yung mga grounds lang provided for by law. Again, number 2 is letter B. Number 3. Which of the following is a valid ground for the exercise of appraisal right? Yung answer ay letter D. Investment of corporate funds in accordance with its secondary purpose. In accordance with its secondary purpose. Kung merong investment of corporate funds other than its primary purpose, pwedeng mag-exercise ng appraisal right. So, kung secondary purpose, pwede mag-exercise ng appraisal right. Tingnan natin yung A, B, C. Yung A, amendment of articles. Hindi naman lahat ng amendment ng articles of incorporation pwedeng mag-exercise ng appraisal right. Limited lang dun sa law. Yung amendment which has the effect of restricting the rights of a stockholder or class of shares. Yung amendment extending or shortening corporate term. Yun lang yung mga grounds doon sa amendments. Yung letter B, sale of corporate asset or property. Dapat all or substantially all. Yan din yung sa C. lease of corporate asset or property. Dapat lease of all or substantially all. So parang no big deal naman, baka isang asset lang yan ng corporation, nagbenta ng old equipment niya. So hindi yan ground for a stockholder to exercise appraisal right. Dapat yung sensitive, all or substantially all. Number 3, again, is letter D, dog. Number 4, statement 1. The dissenting stockholder who votes against a proposed corporate action may exercise the right to appraisal by making a written demand on the corporation for the payment of the fair value of shares held within 30 days from the date of the implementation of the corporate action. False. Ano yung false? Yung from the date of the implementation of the corporate action. Dapat from the date on which the vote was taken. From the date on which the vote was taken. Hindi yung from implementation of the corporate action. Statement 2. If within 60 days from the approval of the corporate action by the stockholders, the withdrawing stockholder and the corporation cannot agree on the fair value of the shares, it shall be determined and appraised by 3 disinterested persons. True. False. True. Letter D, dog. Statement 1 is wrong, statement 2 is correct. Number 5. If a stockholder exercises his appraisal right, all his rights as stockholder are suspended, except the right he is exercising, that is the appraisal right. In which of the following instances would restore his rights as a stockholder? Yung answer ay letter A. Abandonment of corporate action. Pag inabandon yung corporate action, marirestore siya dun sa rights niya as stockholder. Dahil wala nang reason to exercise appraisal right. So babalik na siya dun sa rights niya as stockholder. Tingnan natin yung letter B, C, D. Letter B, purchase of shares by the corporation. Kung yung corporation ay nagbayad doon sa stockholders ng fair value ng shares, yung stockholder na yan ay hindi na magiging stockholder. So mawawala na yung rights niya because he is no longer a stockholder. Letter C, the demand for payment was withdrawn by the stockholder without the consent of the corporation. Sana kung withdraw niya, edi marirestore siya sa rights niya. Kaya lang yung requirement ng withdrawal ay merong consent yung corporation. So kung walang consent yung corporation, hindi valid yung withdrawal niya. So, hindi siya marirestore doon sa rights niya. Pero kung yung withdrawal niya ay with the consent of the corporation, edi marirestore siya sa rights niya. Letter D, the stockholder does not agree on the fair value fixed by the independent appraisers. So, hindi siya nag-agree doon, hindi yan marirestore yung rights niya. Again, number 5 is letter A. Number 6. Which of the following is wrong? Yung answer ay letter C. The members in a non-stock corporation may vote by cumulative voting. Yan yung wrong Sa stock corporations, pwede yung cumulative voting. Pero sa non-stock, hindi pwede. Sabi ng law, yung members may not cast more than one vote for one candidate. May not cast more than one vote for one candidate. So, hindi pwede yung cumulative voting. Tingnan natin yung A, B, at D. Letter A, the right to vote of the members in a non-stock corporation may be denied. Sabi ng law, may be limited, broadened, or denied. Pwede. Letter B, a member in a non-stock corporation is entitled to one vote. One person, one vote. One member, one vote. True. Letter D, the members in a non-stock corporation may vote through remote communication if it is provided in the bylaws. True. Number 7. Statement 1. The number of trustees should not be less than 5 and may be more than 15. False. Ano yung false? Should not be less than 5. Pwedeng less than 5, pero dapat at least 2. At least 2 incorporators sa non-stock corporations, at least 2 trustees. So, pwedeng less than 5. Yung maybe more than 15, correct yan. So, yung mali lang, yung not less than 5. Statement 2, the trustees shall hold office for not more than 3 years until their successors are elected and qualified. True. False true, number 7. So, yung answer ay letter D, dog. Statement 1 is wrong and statement 2 is correct. Number 8. Only a member of a non-stock corporation shall be elected as trustee, except with respect to independent trustees of non-stock corporations vested with public interest. True. The members of a non-stock corporation may directly elect officers of the corporation even if it is not provided in the articles of incorporation or bylaws. Pwede. That is true. So, yung number 8, true, true. Letter A. Number 9. Which of the following is correct? Correct. Letter D, dog. The articles of incorporation may provide that the business of the closed corporation shall be managed by the stockholders rather than by the board. Unique feature yan ng closed corporation. So, kahit walang board, pwede. Tingnan natin yung ABC. False statements. Letter A, all of the closed corporations issued stock of all classes, exclusive of treasury shares, shall be held of record by more than 20 persons. Dapat not more than 20 persons. Letter B, all of the closed corporations issued stock of all classes shall not be subject to restrictions. Shall not be subject to restrictions. Wrong. Dapat shall be subject to restrictions. Letter C, the closed corporation shall list in the stock exchange or make public offerings. Shall list. Dapat shall not list in the stock exchange or shall not make public offerings. Again, number 9 is letter D, dog. Number 10. Statement 1. Any stockholder of a closed corporation may, for any reason, compel the said corporation to purchase his shares at fair value. True. May for any reason. Sabi ng law. Pwede. with respect to closed corporations. Statement 2. No payment shall be made to a stockholder withdrawing from a closed corporation unless the corporation has unrestricted retained earnings in its books to cover such payment. False. Ano yung false? Has URE. Hindi kailangan yung URE kung closed corporation. Yung nire-require ng law lang ay yung sufficient assets to satisfy the liabilities. Not URE. Sufficient assets to satisfy the liabilities. So, yung number 10, true, false. Letter C. Statement 1 is correct and statement 2 is wrong. Number 11. Which of the following is correct? Yung answer ay letter A. Trustees of educational corporations, exception to sa non-stock corporation, should not be less than 5 nor more than 15. Kanina yung general rule sa non-stock corporation may be less than 5 pero at least 2 and maybe more than 15. So dito, kung educational, not less than 5, not more than 15. Yung B, C, D, hindi yan tumugma doon sa requirements na yun. So yung correct ay yung letter A. Number 12. Statement 1. A religious corporation is a corporation sole. False. Not necessarily so. Hindi naman lahat ng religious corporation ay corporation sole. Pwede ordinary non-stock corporation. Statement 2. A corporation sole is a religious corporation. True. True, dahil lahat naman ng corporation sole ay religious corporation. Number 12, false true. Letter D, dog. Statement 1 is wrong and statement 2 is correct. Number 13, statement 1. A corporation sole is formed by the religious leader for the purpose of administering and managing the affairs, properties, temporalities of the church. As trustor, false. Ano yung false dyan? As trustor. Dapat as trustee. Statement 2. A corporation sole acquires juridical personality from the issuance of Certificate of Incorporation by the Securities and Exchange Commission. False. Ano yung false? Yung from the issuance of Certificate of Incorporation by the SEC. Yung correct statement dapat yung from and after filing of the Articles of Incorporation with the SEC. The corporation sole acquires juridical personality from and after filing of Articles of Incorporation with the SEC. Number 13, false, false, letter B, boy. Both statements are wrong. Number 14, which of the following is wrong? Yung answer ay letter C. A natural person who is licensed to exercise a profession may organize a one-person corporation for the purpose of exercising such profession. So, si one-person corporation bawal mag-exercise ng profession. Tingnan natin yung A, B, at D. A corporation cannot be a single stockholder in a one-person corporation. True. Dapat natural person, estate, or trust. So, bawal si corporation or partnership na maging single stockholder sa one-person corporation. Letter B, banks may not incorporate as one-person corporation. True. Letter D, a one-person corporation is not required to have a minimum authorized capital stock. Number 15, Statement 1. A one-person corporation is not required to submit and file articles of incorporation and bylaws. False. Ano yung false dyan? Yung articles of incorporation. Nire-require siya to submit articles of incorporation. Hindi lang siya nire-require to submit bylaws. Statement 2. A one-person corporation shall indicate the letters OPC either below or at the end of its corporate name. True. False, true. Letter D, dog. Statement 1 is wrong. Statement 2 is correct. Number 16. Which of the following combinations may not be occupied by a single person in a one-person corporation? Yung answer ay letter C. Generally, bawal mag-occupy ng dual positions yung president. Yung president and treasurer, bawal yan. President and secretary, bawal din. Yung position as officers of the corporation. Pero dito sa one-person corporation, ina-allow si president to be at the same time the treasurer. So allowed yan, president and treasurer. Allowed. Nire-require lang siya to post a bond. So again, number 16 is letter C. Number 17, Statement 1. The single stockholder of a one-person corporation shall designate a nominee and an alternate nominee who shall, in the event of the single stockholder's death or incapacity, take the place of the single stockholder as president and director and shall manage the corporation's affairs. False. Ano yung false? Yung as president. Dapat as director lang. Shall take the place of the single stockholder as director and shall manage the corporation's affairs. So, hindi siya yung president. Director lang. Statement 2. The single stockholder of a one-person corporation may at any time change its nominee and alternate nominee by submitting to the SEC the names of the new nominees and their corresponding written consent without amending the articles of incorporation. True. So, hindi kailangan i-amend yung articles of incorporation kung palitan yung nominee and alternate nominee. So, number 17, false, true, letter D, dog. Statement 1 is wrong. Statement 2 is correct. Number 18, which of the following is correct? Yung answer ay letter C. A single stockholder of a one-person corporation may be held solidarily liable for the debts and liabilities of the corporation. May be held solidarily liable for the debts and liabilities of the corporation. Tingnan natin yung A, B, at D. Letter A, a single stockholder of a one-person corporation is liable as a single proprietor. Wrong. Hindi ito single proprietorship, yung one-person corporation. Iba yung liability ng single stockholder, limited liability. Letter B, a single stockholder of a one-person corporation is liable as a partner in a general partnership. Wrong. Liable siya as a single stockholder. As a stockholder, limited liability. Si partner ay liable beyond contribution. Letter D, the doctrine of piercing the veil of corporate fiction is not applicable to a one-person corporation. Wrong. Applicable yan. Corporation kasi, the same lang yung rules dito sa piercing the veil of corporate fiction. Yung letter C, si single stockholder, although limited yung liability niya to the extent of his contribution, may be held solidarily liable with the corporation when the single stockholder cannot prove that the property of the one-person corporation is independent of the stockholder's personal properties. Independent. So, kung hindi niya mapuprove na yung properties ng OPC ay separate or independent doon sa properties niya, personal properties, then he may be held solidarily liable. Again, number 18 is letter C. Number 19, when a single stockholder acquires all the stocks of an ordinary stock corporation, the latter may apply for conversion into a one-person corporation. If the application for conversion is approved, the Securities and Exchange Commission shall issue letter A, a certificate of filing of amended articles reflecting the conversion. Hindi pa kaagad mag-issue ng certificate of incorporation, certificate of filing of amended articles. Yun yung i-issue ng SEC. Yun yung dapat. Again, number 19 is letter A. 20. Which of the following is wrong about one-person corporation? Yung answer ay letter C. The one-person corporation has a limited liability. False. Hindi si one-person corporation yung merong limited liability. Si single stockholder. Tingnan natin yung A, B, at D. Letter A, a one-person corporation has a separate juridical personality. True. Letter B, the voting requirements under the Corporation Code do not apply to a one-person corporation. True. Dahil walang votation dito, walang meeting. Dahil single stockholder lang. Yung letter D, the one-person corporation may be converted into an ordinary corporation. True. Again, number 20 is letter C. 21, Statement 1. A foreign corporation without a license to do business does not qualify as a foreign corporation as defined by the Corporation Code, and it has no personality. False. Yung license na requirement ay para lang to sa right to sue ng foreign corporation. Kung napasa niya yung incorporation test and reciprocity test, then mako-qualify na siya as foreign corporation. Walang problema yan. Kaya lang kung walang license, walang right to sue lang. Pero it may be sued. Kaya nga mali din yung it has no personality. it has a personality. Dahil kung walang personality, edi hindi mo siya masusu. Statement 2. A foreign corporation without a resident agent does not qualify as a foreign corporation as defined by the Corporation Code, and it has no personality. False. Yung resident agent, requirement yan dun sa application for license niya. So, walang connection yan sa personality ni foreign corporation. Again, basta mapasan niya yung incorporation test and reciprocity test, it would qualify as a foreign corporation. So, number 21, false, false, letter B, boy. Both statements are wrong. Number 22, which is correct? Yung answer ay letter D, dog. A foreign corporation without a license to do business in the Philippines cannot sue but can be sued in the Philippine courts. Correct. Tingnan natin yung ABC. A foreign corporation without a license to do business in the Philippines cannot sue and cannot be sued. So, yung mali, cannot be sued. Yung letter B, a foreign corporation without a license to do business in the Philippines can sue. Yan yung mali. And can be sued. Yung letter C, a foreign corporation without a license to do business in the Philippines can sue. So, mali din. But cannot be sued in the Philippine courts. So, yung correct, again, ay letter D, dog. Unlicensed foreign corporation may maintain an action in the Philippine courts under the following instances, which is the exception. Letter D, dog. Yung ABC, yung common denominator, ay hindi nagdo-do business. So kahit walang license, pwedeng pumunta sa Philippine courts. Number 23 again is letter D, dog. 24. Which of the following does not require revocation of certificate of incorporation and issuance of certificate of dissolution by the Securities and Exchange Commission? Yung answer ay letter C. Voluntary dissolution by shortening corporate term. So, hindi na kailangan ng intervention ng SEC. Pag-expire ng corporate term, automatically dissolve na yung corporation. Yung letter A, B, at D, kailangan pa ng action ng SEC. Yung A at B, voluntary dissolution where no creditors are affected, and voluntary dissolution where creditors are affected, dapat mag-i-issue pa ng certificate of dissolution yung SEC. Yung letter D, involuntary dissolution by continuous inoperation of a corporation. Nag-incorporate, nag-organize, nag-do business, pero hindi nag-continue for 5 years. Lalagay siya doon sa delinquent status. Pero bibigyan pa siya ng chance to resume operations within 2 years. Pag hindi siya naka-resume operations within 2 years, i-revoke ng SEC yung kanyang certificate of incorporation. So, merong action coming from the SEC. Again, yung number 24, letter C. Number 25. What is the voting requirement for voluntary dissolution where no creditors are affected? No creditors are affected. Letter A. Majority of the board and majority of OCS or members. No creditors are affected. Yan yung voting requirement. Bakit hindi yung C? Approved by the board. Approved by the board. Yung letter A, majority vote dapat of the board. Hindi lang yung majority of those present. Yung letter C, sinasabi niya approved by the board, yung parang ordinary corporate action na majority of those present. So, dapat letter A. So, again, number 25, letter A. That ends Part 5, Quaesar Corporation Law Review.